Well, new developments in the National Security Agency's controversial spying program. A New York U.S. District Court judge ruling today the surveillance program is legal. Now, this decision comes after another federal judge in Washington ruled the opposite way earlier this month. Could this conflict mean this issue is ultimately on the fast track to the Supreme Court? The ACLU, which filed that New York lawsuit challenging the NSA program, offering this statement on the ruling, quote, "We are extremely disappointed with this decision as another federal judge and the president's own review group concluded last week the National Security Agency's bulk collection of telephony data constitutes a serious invasion of Americans' privacy. We intend to appeal and look forward to making our case in the Second Circuit." Jay Sekulow, Chief Legal Counsel for the American Center for Law and Justice, joins us live. Jay, great to see you tonight. Your take on today's ruling.
Good to see you, Shannon. Well, it's interesting because you've got now within the last week two significantly conflicting decisions. One out of the court that's going to be governed by the Second Circuit, the one today. The other out of the D.C. U.S. District Court, which would be the D.C. Circuit Court of Appeals. That means we're going to have, I think it is fast track to the Supreme Court. And this is a very important issue and a significant issue. And the courts are diametrically opposed in their position. You've got one judge, John Leon, saying that this was an unchecked, unbridled, limitless in scope invasion of Fourth Amendment issues. That is the idea that you have the right, some rights of expectation of privacy with data. And then you have the judge today deciding that, in fact, that this was the government's attempt to counteract al-Qaeda. The problem is, from a legal standpoint, it's limitless, and it's the NSA program as it is now is not focused. It's limitless. So to apply these kind of basically huge data gathering without any evidence that the person engaged in, that you're getting this information on, may have ties to a terrorist group or is making calls that meet a data requirement, those limits are not in place. So I think it's troubling from a constitutional perspective. But look, these are close calls, and I'm in favor of the Patriot Act. I'm still in favor of the Patriot Act. These are going to be a close call and be close to the Supreme Court, I suspect.
Well, and there's this conversation about finding that balance between protecting the country and also protecting the privacy of Americans, things embedded in the Fourth Amendment on search and seizure, as you mentioned, and something that privacy, Americans guard very, very closely. It's an important bedrock and something unique to our society. So basically what I read in Judge Pauly's opinion today was sort of this undercurrent, a message that, listen, I'm applying the law as it exists. Congress has renewed Section 215 that specifically applies here numerous times. I almost got the feeling that the subtext was, I'm applying the law as it's written. If you don't like it, it's going to be up to the other branches to change it.
Well, he said that basically. I mean, you're right. He said that, look, his job is to determine the constitutionality of it. If there's concern about the law, and he expressed that there could be, serious concerns with the law, that in fact that it is the legislative branch and the president, the executive branch, that would have to deal with this. I think that the issue for the American people is this. Is this data gathering the most effective way we have in combating what I believe is an ongoing and continuing threat against the United States and our interests? And I think that threat is real. But the question is this data gathering, the way they're doing it, with these unbridled checks, with limitlessness in scope, and not focus? No one wants to say the word profile, but you know what? When you have crimes, you profile. You look for a particular potential defendant's behavior patterns, who they are, who they're associating with. That's the kind of focus we need. The Israelis are very good at that. They don't have to gather this kind of data through telephony, which is what we're doing here. They can get it other ways. And I think there's more effective ways in this giant scope of data gathering. I think it's got Americans concerned. Again, it's a close call in the courts, but it's a big issue with serious repercussions about how we balance liberty and security. And I don't think you want to surrender liberty, but we certainly don't want to surrender security either. That's going to be the issue squarely before the courts of appeals and ultimately the Supreme Court.
Yeah, and at least one Supreme Court justice already saying he doesn't think they're the best body to decide this, but they may not have a choice. Jay, thank you very much. Good to see you.